Hey guys, unexpected live stream because there's been some big documents dropped in the Delphi case. This is just crazy and amazing. Brad Rosie, Richard Allen's attorney, has filed several documents. I found 3 documents. There may be more, but I think the two that I'm going to read you are enough here to to basically just say Brad Rosie is putting himself on the line, totally on the line. And why is he doing that? Is he doing it because he feels slighted, because the judge has put his nose out of joint? Maybe. Or maybe, as well as that, maybe even more so than that, he truly believes his client, Richard Allen, is innocent. So, it's all shocking turn of events, Sharon. Everything in this case lately, since the 136-page memorandum, which seems like forever ago now, but it was actually only last month. It seems that every day there's something, or almost every day. So, without further ado, I'm going to read through these. One's 4 pages, one's 8 pages. So, wow. Yeah, I saw these. I got these from Twitter. And I've no idea how many more people are live. I'm guessing just about everybody covering the Delphi case is live right now, or is about to go live anyway. So thank you for choosing to be here rather than anywhere else. But without further ado, I'm just going to start reading. And I haven't read them all thoroughly. I've just done a skim read just to get the basic gist. And then I just thought, this is huge. This is huge. I said, when that memorandum came out, I said, this is a career make or break moment for these attorneys. And it seems that the judge has tried to break them. And certainly Brad Rosie isn't going quietly into the night. He's fighting with everything he's got. And honestly, I am expecting a response also from Andrew Baldwin, because I can't see Andrew Baldwin going quietly into the night either. I really can't. But, okay, so this is verified notice of continuing representation. So, so it goes back, right? So it was appointed in November 2022, Richard Allen. So, Brad Rosie and Andrew Baldwin, they both have private practices, but they're appointed to Richard Allen as public defenders. So, am I planning to cover the Koberger hearing in 15 minutes? I know it's happening. But no, at the moment, I'm concentrating on this. So I'll talk about that tomorrow, if that's all right. Okay. Oh, his Defense Diaries gone live. I like Defense Diaries. I've got really into Defense Diaries, so I'll go and check that out after. Okay, right, without further ado. So this takes us back to the week before October the 19th, which was the hearing that wasn't. And it's a blow-by-blow account of what happened. So he really is putting his neck on the line. And I think that it's a huge testament to him as a lawyer and as somebody who is willing to go above and beyond and put himself on the line for his client. And there's no other reason he'd do this. No other reason he'd do this other than truly believing that his client is innocent. Okay. On October 12th, 2023, Aussie TV, member for 11 months. Yes, you made it. Yes, you did. The court communicated with Prosecutor McClelland, Attorney Rosie and Attorney Baldwin, at which time the court ordered attorneys Rosie and Baldwin to cease work on Mr. Allen's case. So if anybody can remind me when did it come out that she demanded them to be there in her courtroom on October 19th? It must have been shortly after this, on or just after October 12th. But she told them to down tools. She told them that from now on, you are not to work on Richard Allen's case. This is how can a judge order you to do that? How can a judge tell you to stop working on your client's case when there's been no discussion, there's been no communication with that client as to why work has ceased? That point in itself surely is wrong. Surely. The chilling effect of the court's emailed order was to essentially strip defendant Allen of his Sixth Amendment right to representation. And Sixth Amendment, doesn't it say, we went through this in the last live, I think, or the live before that, the Sixth Amendment, that not only are you entitled to representation, you're also entitled to representation of your choice. And surely it doesn't matter whether you're using a court-appointed public defender or not. Once your team has been appointed, surely then it's your choice as to whether you want to continue with that team or not. But hey, okay. So, strip defendant Allen of his Sixth Amendment right to representation and essentially disarmed attorneys Rosie, Baldwin and defendant Allen during the week leading up to the scheduled hearing, which was ordered by the court. Some Latin word. All right. In an October 17th, 2023 email, Attorney Rosie requested a conference to determine what we, the court prosecutor and defence counsel, are trying to accomplish on Thursday. So Rosie emailed them and said, right, what's the crack here with this? Especially in terms of what's expected of us while we were on record in open court. In response, the court, so Judge Gull, ordered both the defence and prosecutor to appear in chambers at 12:30 p.m. on October 19th. So an hour and a half before the hearing was scheduled to go ahead. On October 19th, 2023, attorneys Rosie and Baldwin appeared at, like I said, I'm just getting these from Twitter, appeared at the Allen County Courthouse in advance of the 2 p.m. hearing. This was prompted by Attorney Rosie requesting that the parties communicate in advance of the scheduled hearing. Attorneys Rosie and Baldwin appeared in chambers on the 19th at approximately 12:30 at which time the prosecution was present. Attorney Rosie is of the understanding that the court reporter secured an audio recording of the in-chambers conference, which took place in 2 parts. The court first conducted business as it related to several pending motions by communicating with the parties and issuing rulings on said motions. Okay. The court then read a prepared statement. So when it says the court, it means the judge. Right? That's what it means. Who's trolling? Come on now. Who's trolling? Listen, this is too big for somebody to be trolling. If you're trolling, cease forthwith. Stop now. Cease forthwith. Oh, DJ, you've never been in such a more unwelcoming chat. Well, all right then. Let me do something good for you then. Let me do something good for you. Something that will make you feel better. There you go. You've got a little timeout. How's that? How's that? Sit on the naughty step and think about what you've done, DJ. I don't even know what you've done, but yeah, you've got 300 seconds in timeout. Okay. The court then read a prepared statement to attorneys Rosie and Baldwin, identifying various issues throughout the case through which attorneys Rosie and Baldwin exercised gross negligence. Gross negligence. What? This judge isn't used to attorneys actually fighting for their client. Oh, I see. Okay. In carrying out their responsibilities as counsel for defendant Allen. The court then suggested that attorneys Rosie and Baldwin engage in a discussion outside of chambers regarding the allegations. Attorneys Rosie and Baldwin asked for clarification, at which time the court communicated to attorneys Rosie and Baldwin that there was 2 distinct options. 1, either voluntarily withdraw their appearances and exit the courthouse in advance of the hearing, or 2, participate in the 2 p.m. hearing in the courtroom where a media camera was installed, the national media was present, and the law enforcement community was seated in the jury box directly behind defense counsel table, at which time the court would read the prepared statement into the record and then disqualify both attorney Rosie and Baldwin in the presence of defendant Allen, his family, and the general public. That, my friends, is shocking. Shocking. Oh, what? There's another active shooter in New Jersey. Oh, dear me. Exactly, Sleuthing Sandals. The judge sounds biased. Exactly. So basically, you get an email telling you to stop, cease, do no more work for this client. You're ordered into a hearing that you don't know what it's about the following week. You try to communicate. The judge tells you to turn up an hour and a half before the hearing. You turn up an hour and a half before the hearing, and then you're given 2 choices. Either withdraw your counsel due to gross negligence when you don't even know what the gross negligence is, or in front of the entire world, a prepared statement will be read into the record in front of the entire world. Come on now. In what world is that fair? That's shameful. That's shameful. Shameful. Look, this leak of the crime scene documents, the crime scene photos, yes, that was bad. Yes, ultimately, it's Andrew Baldwin's responsibility. And I've talked about this in videos this week. It's ultimately his responsibility to make sure that there's no one in his office who used to work there, whether it's his friend or what. Ultimately, it's his responsibility. It's understandable that he's going to trust his friend. I talked about this yesterday or the day before, I can't remember. It's understandable that he's trusted his friend and his friend has betrayed him. It's understandable that he's let his guard down. He's let his guard down in front of somebody who worked in that very office with Andrew Baldwin for 7 years. Why would you assume that somebody who's your friend, who you've worked with for 7 years, is going to betray you like this? You wouldn't assume that. But it's got absolutely nothing to do with Brad Rosie. Nothing to do with him. Because Brad Rosie has his own firm. The reason why Richard Allen was appointed 2 attorneys was because this is a big case. Right? Look how many attorney Koberger has on the public dime. He's got about 10 now. Thank you, Krista, for the 1999. Thank you so much. It's very kind of you. I think he's got 10, Koberger, at last counts. So having 2 is perfectly understandable in a murder case of this magnitude. But they come from different firms. So whatever Andrew Baldwin did in his office that caused a leak has got absolutely nothing to do with Brad Rosie. And I assumed that she would fire Baldwin, that, you know, she's giving him an ultimatum, basically. But Rosie, I thought Rosie had had chosen to, I don't know, walk away because perhaps he didn't feel like working with a new person, because that new person is going to be playing catch up. And, you know, there might be disagreements in the way that they're going to work and all sorts of things. So he's just taking himself out of this situation. That's what I assume. But no. That's not what happened. Let's keep reading. After waiting approximately 1.5 hours for defendant Allen to arrive at the courthouse, Attorney Rosie and Attorney Baldwin communicated with defendant Allen regarding the stark choice the court had offered in chambers. Richard Allen must have been utterly befuddled by, I mean, come on, can you imagine? Defendant Allen reaffirmed his desire to move forward under the representation of attorneys Rosie and Baldwin. So on October 12th, Attorney Rosie filed correspondence with the court. Said correspondence contained a letter dated October 11th, signed by Defendant Allen, wherein Defendant Allen acknowledged he was aware of the issues regarding crime scene photos that were stolen from. It's going over the next page. We'll read it on the next page. Okay, so as of October 24th, Defendant Allen objects to the court's attempts to strip him of his current counsel, Rosie and Baldwin. Okay, next page. So let's just read that. So crime scene photos, Attorney Baldwin's office, from Attorney Baldwin's office, and desired that Attorney Rosie and Baldwin continue on with their representation. So Richard Allen's been aware of the leak and he still wants them to continue. So they've preempted anything problematic for Richard Allen by raising it to him previous. Okay. After speaking with Mr. Allen, Attorney Rosie and Attorney Baldwin then returned to chambers, at which time Attorney Rosie articulated to the court that the court had engaged in an ambush of defense counsel, entirely void of due process, totally is, and that Attorney Rosie would withdraw his appearance. But that said, withdrawal was not a voluntary withdrawal because the court made clear if Attorney Rosie did not agree to withdraw, the court would publicly shame him in front of the world and his client before forcing him off the case by disqualifying him. All of the events in chambers occurred without any formal allegation of contemptuous behaviour by attorney Rosie or Baldwin. So not even give him a dressing down. Like, what is it? What are the formal allegations that they've broken? What have they actually done? Like, the judge surely has to give a reason, not just gross negligence. She's got to actually give reasons to do this. It's crazy. Okay. So no formal allegations of contemptuous behaviour by attorneys Rosie or Baldwin without any pending pleadings requesting disqualifications of defence counsel and without any pending disciplinary complaints with the Indiana Supreme Court's Disciplinary Commission. In total, attorneys Rosie and attorney Baldwin have practiced law in the state of Indiana for more than 50 years without a single substantiated finding of a disciplinary action against either. At no time while in chambers did the court ever articulate to either attorney Rosie or Baldwin that their conduct compromised defendant Allen's defense in any way. In fact, defendant Allen himself doesn't believe this to be the case. There's no bona fide facts or circumstances wherein attorney Rosie engaged in gross negligence. There isn't. This seriously isn't. If she wanted to make that case for Baldwin, then she needed to make that case for Baldwin. A leak of crime scene photos, is that negligent? Yes. Does it deem gross negligence? I'm not sure. When it's not him that's doing the leaking. But Rosie did nothing. Rosie works in a different office, completely different firm. Nothing to do with him. So to fire him and to threaten to do it so publicly, I mean, this is the reason. Come on now. This is the reason why she allowed cameras in the court for this hearing, isn't it? Now we know why she wanted cameras in the court for the first time ever. Not because that's what the defense attorneys wanted, but because that's what she wanted, so that she could name them and shame them in this way. Shocking. There is something very deeply corrupt about what's going on in Indiana in this case. Deeply. Okay. So, no circumstances where attorney Rosie engaged in gross negligence, nor was there any showing of any conduct by attorney Rosie resulting in negative consequences of another party, i.e. defendant Allen. In sum, attorneys Rosie and Baldwin did nothing to compromise Richard M. Allen's defense. Attorney Rosie's oral acquiescence to withdraw his appearance as defendant Allen's attorney was forced, coerced, and driven only by the circumstances created by the tribunal, which delivered two terrible options: quit or be shamed in public before being disqualified from representing Mr. Allen. I mean, okay. The court's premeditated ambush of the defense placed attorneys Rosie and Baldwin and their client Richard Allen in a most compromising position. The trial court stated intention to read a prepared statement criticising defence counsel created an impossible ethical bind. If counsel did not agree to withdraw in chambers, the trial court would publicly disparage their representation of the accused. framing their advocacy on his behalf as gross negligence. I thought when she came into court and she just looked annoyed and exasperated, I thought it was because he decided to quit, that she wanted Baldwin out, but she didn't expect Rosie to jump as well. And I thought she just looked annoyed, exasperated. But no. She was fired up. Maybe she wanted a public showdown. Maybe she looked annoyed because she didn't get her public showdown that she wanted, that she got the cameras in the court, especially, that she thought, oh no, they're not going to just quit on me. They're going to want to fight, and I'm here for it. Maybe that's what she was doing. Thank you, Lynn, for the $9.99. That's very kind of you. Oh, it's not a super sticker, so I can heart that. I can heart super chats, but I can't heart super stickers. Okay. All right. Casting both counsel and the merits of their client's defense in a negative light. This public statement and circumstance created by the trial court risk tainting the jury pool, harming the client's defense, undermining their professional relationship with the client, and possibly creating an actual conflict for their continued representation. The jury trial in this matter is set to commence on January 8th, 2024, a full 1 year and 3 months after the arrest of defendant Allen. The appointment of successor attorneys will prejudice defendant Allen by and through further delays in his case. Absolutely. He's gonna sit in jail. No, sorry, guys. He's gonna sit in prison, right, for what? The next, year, 2 years? Because this sets everything back to day one. So them gearing up for trial, the amount of work they've done, Richard Allen gearing himself up for the trial, all down the drain. Let alone Abby and Libby's families. Let's not forget them. Their families are denied the trial for a year, 2 years. Do you think they want that? No, I would expect not. Exactly, Mike. Prison with his Odin guards. Exactly. I want to know what affiliation this judge has. Does she have friends in Odinist circles as well? It begs the question. Why she has chosen not to allow Richard Allen to move from Westville to Cass County. Cass County Jail offered, well, they didn't offer, but they agreed to have him. They said, we've got the facilities in our county jail to house him and look after him. But no. Judge Gull didn't want that. Judge Gull wanted to keep him at Westville. I wonder why. Okay. The appointment of successor attorneys will prejudice defendant Allen by and through further delays in his case and trial. If, however, Attorney Rosie moves forward with his representation of defendant Allen, there will be no need for 2 newly appointed attorneys to dedicate hundreds and thousands of hours towards a mere review of the discovery, which continues to pour in as recent as late September. There will be no need to marshal all the discovery and return it to prosecution. Yeah, and also it will mean that the prosecution can't tamper with it before they give it to the new prosecutors, the new defenders. There will be no need to bring up to speed new staff members, investigators, and possibly a new set of experts to address the many complicated issues that have already been addressed by the defence. A new defence team would likely result in a shifting of the strategy and approach of Allen's current defence team, which in turn would further delay and compromise Richard Allen's defence. Finally, any successor lawyer would have the convenience of working with Attorney Rosie to become familiar with the subject matter in a more efficient and fiscally responsible way. All these truths weigh in favour of Richard Allen's choice to maintain Attorney Rosie for his counsel of record. So DC Primetime, the member links in the description box. Genealogy of the key players. I'd need to know their parents. Well, it depends on their age. Parents and grandparents. I'd need to do a genealogy. If they're young, I'd need their grandparents. If they're old, parents is usually okay. Jenny, welcome. Thanks for joining the Secret Agents Club. Okay, so let's move on. All right. Yeah, I mean, the thing is, DC Primetime, welcome to the Secret Agents Club. Thanks for joining. You found the member link. It is insane. It is insane. Yeah, Westfield prison is a hellhole. I mean, look at the expense of employing two new public defenders when neither of his current or previous public defenders wanted to go. I mean, she's obviously doesn't care about the taxpayer dollar, does she? There are no circumstances under Rule 1.16 of the Indiana Rules of Professional Conduct which warrant the withdrawal of Attorney Rosie's representation of Defendant Allen. Attorney Rosie notices up this court of his intention to move forward with the representation of Defendant Allen until a final disposition of this matter. So he intends to stay on, but that's not the biggest thing. So that's what happened. That's the blow-by-blow account. However, like I said, I'm getting these off Twitter because I'm lazy and I can never find the court clerk thing. No motion to disqualify. Lisa, member for 11 months. Thank you for your continued support. You're nearly a year in, nearly a year. Sharon, thanks for joining. Welcome to the Secret Agents Club. Down Under with Love has passed the year. Member for 13 months. When you thought the circus couldn't be bigger, I know. It's like one of these like crime shows on Netflix. Netflix could not make this up. They really couldn't. But yet, meanwhile, this is all too real for two families who've lost daughters, granddaughters, sisters, nieces, cousins, and also Richard Allen's family, who is in complete and utter disbelief and disarray. For Richard Allen himself, for the town of Delphi, who've lived with this for nearly 7 years. And January was like the finishing mark. You know, it was like well, here we are, finally at a trial. And let's see what the jury makes of the two very opposing sides. You know, is it that Richard Allen is truly innocent and, you know, he's a wronged man and the attorneys are right in standing by him, defending him, putting together a a crazy 136-page memorandum, but could it possibly, or at least some of it, be true? Could it be true that he really is innocent and he's been framed? Go and watch my video from this morning. That bullet was not there in Ron Logan's search warrant. Go and watch it. The magic bullet, where did that come from? All right. Motion to disqualify. Kyle's running up and down stairs. Is Eloise coming round or something?
No, they're football boots.
Oh. What's that smell?
Febreze.
Oh. That's why I thought she was coming round.
That's cleaning my boot smell.
Oh. I thought Kyle's girlfriend was coming round because he started spraying air freshener all over the place. But he was actually cleaning his football boots. He cleans his football boots with air freshener. The chat says hi, Kyle.
Hello.
All right. Thank you, Nikki, for joining the Secret Agents Club. Thank you. Thank you. She's not coming round. It's all right. He can go back to his room now. He's been running up and down stairs. I don't know whether the mic was picking it up. I don't know. He's run up and down stairs about 10 times. I don't know why. If he was just cleaning his boots, that he needed to do that. But anyway, I was trying to ignore him. But anyway, okay. So motion to disqualify. Now this is 8 pages. Okay. So the accused by counsel and pursuant of Rule 2.11 of the Indiana Code of Judicial Conduct, blah 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 blah, would respectfully and moves for recusal and change of judge from Judge Francis C. Gull. Seagull. Seagull. Okay. Okay. So I think this is a little bit more technical. Or to be young again. I know, yeah. If I run up and downstairs 10 times, I think I'd definitely need to lie down. All right. So Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to disqualify him or herself when the judge's impartiality might reasonably be questioned. Well, say it like it is, Brad, because it does seem that she is very compromised. It's questionable. Such is the case in this cause of action for the reasons described below. The comments to Rules 2.11 provide additional guidance. 1. Under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. In many jurisdictions, the term recusal is used interchangeably with the term disqualification. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. A judge must disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. Okay. Judge Gull has removed and concealed or allowed to be removed by the clerk of Carroll County defense pleadings from the chronological case summary in violation of the Indiana Supreme Court administrative rules. Okay. These pleadings include Frank's. I should just go and get these from the court, and then it will just be one document. Court's motion filed 9/18/2023. So she's removed these. Frank's memorandum filed 9/18/23. 3 affidavits were Warden Gallipo, Sergeant Jones and Sergeant Robinson. I think she's just sealed them rather than just remove them. I think they're removed from the public. So she's made the choice of sealing them just because she doesn't want them out there, because it doesn't fit her narrative. So she's got to remove them. Doesn't matter that we've all got them anyway. Oh dear. So the warden and Sergeant Jones and Sergeant Robinson, you know, the ordinists, filed 10/10/23, and the affidavit of the leaker, Mitch Westerman, Judge Gull has not removed or hidden or any. The affidavit of the leaker, Mitch Westerman, Judge Gull has not removed or hidden any state filings. Indiana access to court record rules provides in pertinent part all persons have access to court records as provided in this rule, and that certain persons have greater access to court records. The commentary, blah, 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 is that all persons, including members of the general public, the media, and commercial and non-commercial entities, are entitled to the same basic level of access to court records. Isn't this refreshing that a defense wants the records to actually be out there rather than behind a wall where no one can see them? Isn't it refreshing that they want transparency in this matter? Okay. So Rule 4 provides that a court record is accessible to the public except as provided in Rule 5, which is entire cases shall be excluded from public access without notice of exclusion, but this entire case has not been declared confidential by statute or rule and meets none of the other criteria laid out. Okay. So Rule 5b provides a process for excluding individual case records. However, none of the 13 listed grounds for excluding public access to the records secretive from the docket in this case apply to the above referenced documents, which have either disappeared or are inaccessible to the public, nor were the documents filed using the procedures required by Rule 5. Okay, blah, blah, blah. Okay, these are just specific things. By secreting pleadings from the docket without forwarding the access to court records, to court record rules, Judge Gull has allowed violations of public access. Because those acts have only shielded documents from the defense, these actions clearly demonstrate a lack of impartiality and fairness in violation of Judicial Rule 1.1 and 2.2. Okay, we're getting to the specifics now. We're getting to the specifics. There's been a lot of speculation that the Assistant DA, former mayor, is involved. Involved in what? Involved in ordinism or what? Exactly, he shouldn't have been treated differently. He shouldn't have been treated any differently. He should be in a county jail. If it's good enough for Coburger, good God, okay. Imagine Ann Taylor if Coburger had been put in some kind of penitentiary with ordinary guards. She'd have gone in and broken him out herself. All right. Okay. On October 12th, 2023, Judge Gull instructed appointed counsel to cease work on Mr. Allen's case, which interfered with the attorney-client relationship and prejudiced the accused by denying him the timely and effective representation guaranteed him by the state and federal constitutions. On October 19th, Judge Gull conducted critical stage proceedings in chambers outside of the presence of the accused, even though she had ordered him transported and he was available. Surely she can't fire his attorneys or give them some kind of ultimatum without him being there. How is that even? It's not right. She then did the same after placing his attorneys in an ethical dilemma and again creating a public record outside of the presence of the accused. This ignored clear precedent. On October 19th, Judge Gull ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. So what came out in the media earlier this week, talking about coercion, well, here it is. It wasn't just something that the media had made up or, they kind of twisted a word. No. The choice presented was to suffer a public shaming and be removed from the case or to voluntarily withdraw, despite defence counsel requesting clarification as to the topics and or motions to be addressed. At the October 19th hearing, she gave defence counsel no notice of her plan to force withdrawals or remove them, thus denying counsel the opportunity to adequately refute her accusations. Yeah, well, maybe Rosie feels like that, but Baldwin had at least some inkling, shall we say, because he got his own lawyer, David Hennessy, to draft up his own motion for all the reasons why Baldwin should be allowed to stay. So Baldwin had an idea of what was coming. Right? Maybe the judge had a private word with him. Maybe he was just astute and realised what was happening. But Rosie had no such need. This must have come completely out of the blue for him, because this was all about Baldwin and his office. Nothing to do with Rosie at all. T-Love, member for 20 months. Wow, that's a long time. That's nearly 2 years. Okay. So I gave no notice of her plan to force withdrawals or remove them, thus denying counsel the opportunity to adequately refute her accusations. The same day, Judge Gull had a prepared statement that she threatened to read to the public, alleging defence counsel was grossly negligent in their representation of defendant Allen. Imagine that. Imagine what that would have been like for Rosie and Baldwin. Like, that would have destroyed their careers to do that so publicly with no way that they could refute it, no way that they could argue it without looking even worse. That is dreadful. That is dreadful. Judge Gull's complaint was more about not having control over counsel rather than any legitimate concerns that counsel had engaged in conduct that compromised Richard Allen's defence. They have been the best attorneys. I'll say it yet again. If I ever commit a crime in Indiana, not that I've ever been to Indiana or have any plans to go, but if I ever do commit a crime in Indiana, I want them to represent me. Because especially if I'm accused of a crime when I'm innocent, I definitely want them to represent me, because they are absolutely 100% pulling out all the stops for Richard Allen. And this is what counsel should look like. Maybe it's not what Frances Gull is used to. Maybe Frances Gull is used to getting her own way, and, her buddy McClelland is used to getting his own way. How can she be objective now? How can she be a judge? How can the scales of justice sit in her hands now? They can't. They can't. A general summary of Judge Gull's complaints are as follows. Okay, so this is what Judge Gull has complained about. A press release, generic in substance, was issued by the defence in November 2022 before the court's gag order and only after repeated press conferences by the prosecution. Allen's response. The intent was only to level the playing field. This was well within the obligations of the defence counsel by established guidelines. She never expressed any concerns over the multiple press conferences by the prosecution. Yeah, I remember that. It's before the gag order, so why shouldn't they produce their own press release? Why shouldn't we? Why shouldn't they? Okay. 2 motions filed by the defence, one of which addressed the health and safety of defendant Allen, and the second of which addressed the immediate transfer of the accused due to not so coincidental and undisputed facts that individuals engaging in Norse paganism practices may have not only murdered two... Oh my God! He's gone there. He's gone there. Oh, I've got goosebumps. He's actually gone there. Let me read that whole thing again. 2 motions filed by the defence, one of which addressed the health and safety of defendant Allen, and the second of which addressed the immediate transfer of the accused, so from Westville to Cass County. Cass County agreed to have him, due to the not so coincidental and undisputed facts that individuals engaging in Norse paganistic practices may have not only murdered 2 girls, but that were also escorting defendant Allen around the prison at the same time his health was in rapid decline. Oh, wow, he's gone there. He's gone there. I'm loving this guy. Rosie. That's an Italian name, Rosie, surely. Is that Rosie? Rosie. Should be Rosie. Fire. Mind blown, I know, yeah? Boom, I know. That's it's true though. It's true though. If what they are saying is true, or at least what they believe is true, he's gone there. Allen's response. The court. Allen's response. The court has previously ordered the accused transferred to a state prison at the request of the Carroll County Sheriff. His mental and physical health began an immediate decline. Prison guards in his area had Odinist emblems on their uniforms, which endangered their client after the Odinist connection was exposed. The defence has videos of the patches and the guards admitting that they worn them. The defence has previously noted a connection between the murders and Odinism. The patches have since been removed. Mr. Rosie cites instances of abuse. Those filings were within the obligation established guidelines imposed for effective representation. So we know Richard Allen's mental health was in decline. We know that these 2 guards wore patches that could be, in their own words, the affidavits, in their own words, right, could be seen as Odinist in nature, but they didn't wear them for that. They wore them because they were Norse pagan heathens. Okay, so So we've got semantics going on. Thank you, Wood Chipper, for the $5. That's very kind of you. We got some semantics going on. But any which way, they've now taken the patches off, but are still looking after in the broadest sense, i.e. abusing Richard Allen. Now, they tased him twice in May. So they admitted to tasing him twice, but, well, how many more things have they done? Have they deprived him of food? Have they just come in and give him a quiet dig? Have they deprived him of sleep? What have they been doing? Really? Mr. Baldwin has drafted an email to co-counsel, but sent it to the wrong person due to a self-populating in electronic mail. Oh, I do remember that. Yeah, I remember that. He sent part of the discovery to somebody. It was meant to be Brad, but he sent it to someone else by mistake. I've done that. Come on. Have you done that? Right? Have you done that? This was an accident that happens routinely in most people. The intended recipient, attorney Bradley Rosie, the unintended recipient share the first three letters of their first names. The email attachment contained no substantive information, just a bare bones outline of a tiny portion of the discovery received by the defense in this case. I once wrote an email, right? I once wrote an email about someone. I mean, it wasn't really nasty, but it was like me whinging about somebody, right? This is in a work setting, me whinging about somebody. And then I sent it to the person that I was whinging about. Oh, that was embarrassing. I had to try and make it like a joke, and but anyway, they didn't care. But yeah, we've all been there with emails or texts or whatever. All right. The court alleged that Mr. Baldwin put improper statements in his Frank's memorandum. Not false or misleading statements, just improper in her opinion. Well, you can't just say what's improper. Like, what? Is it not the right legal jargon or what? Okay, we've got to go here now. Okay, Alan's response. The court has disdain for the defence for not filing it under seal, even though there was no order to do so. That memorandum was demanded by the prosecution before there could be a Frank's hearing. It is an impressive piece of legal writing. It's an impressive piece of writing with some legal elements to it. I was impressed by it. I'm not saying that every word is objectively true, but it's a seriously good piece of defense. Let's put it that way. Seriously good piece of defense. Which has been lauded by expert defense counsel across the nation. Has it? I don't know. Maybe it has. Maybe it's put everyone else to shame. What other public defender would write a 136-page memorandum for their client who is not paying them, the state's paying them, less than they get from a private client, right? And literally put their career on the neck. They put their career on the neck for it. They put their neck on the block for it. Oh, yeah, I don't engage in group chats. I cannot engage in group chats because I lose track of who I'm talking to. It's dangerous to do that. Snookered in Delphi, yeah. There's a book title. Yeah. Okay. It again was required by applicable guidelines. That Mr. Rosie has filed a tort claim notice to preserve the rights of his client. A tort claim, so a civil claim. So Mr. Rosie's filed a civil claim to preserve the rights of his client. The court opined that this action amounted to gross negligence. What? Okay, well, this is news to me. The filing of the notice was intended to preserve the rights of the man who was shuttled off to one of the most secure detention units in the state, locked up and isolated with only a tablet, which was often dysfunctional, to communicate with the outside world. Alan has no ability to speak with his wife in private, as his phone calls are all recorded. Well, yeah, and we know that all jail calls are recorded. We know that. We know jail calls are recorded, so that's fair enough. Alan's own attorney were required to make advance reservations to visit him at the prison. It's entirely impractical that Alan would have had the means to prepare his own tort claim notice and or to secure private counsel to do so. Thank you, Stephanie, for the $25. Thank you. That's very kind of you. I can heart that. Thank you so much. Something sure is hinky in Indiana, I know. So she complained that Mr. Rosie has filed a civil claim to preserve the rights of Richard Allen. So the judges complained about that. Wow. So presumably Rosie's done that on his own dime. Like, he won't be paid to file a civil suit for Richard Allen, would he? Surely. I don't know. Maybe he would. I don't know. Okay. She's complained that Mr. Baldwin hired his own lawyer. She complained that he hired his own lawyer. Why would she complain that Baldwin hired a lawyer? Good news, re Koberger. We'll slip Koberger in at the end, just a little bit. What's the good news, though? I need to know now. So she complained that Baldwin hired a lawyer. Wow, this is a judge. This was not true. Mr. Baldwin was betrayed by a friend, and there was a subsequent related suicide. As a friend and colleague, David R. Hennessy suggested he needed a lawyer to speak on his behalf, and he volunteered. No fee was arranged between the two. The court also, even if there was a fee, it's nothing to do with her. If he got wind that he was going to be fired or something untoward was going to happen, he's perfectly within his rights to hire a lawyer. Cameras are allowed. Ah, brill. So the judge. Wow. So the judge disregarded what the defense and the prosecution had to say in Idaho. Wow. It's like Tale of Two Cities. It's light and dark with these people. Can't deal with it. All right. Even if Baldwin had paid someone to represent his interests and write that motion for him, that should not be a problem for a judge. Don't they always say, get a lawyer? She doesn't like it, though. Wow. The court also alleged undersigned had put volatile facts in the memorandum regarding possible sanctions or disqualifications. The true facts in the criminal case are often volatile. There was no untruth. You can't say volatile facts. A fact is a truth. A fact is something that either is or isn't. A fact is a real thing, not an opinion. A fact is a real thing. Thank you, Ashley, for the $10. Thank you, thank you. $10 holler. Ah, dear. The dissemination leak of crime scene photographs in which neither Attorney Rosie or Attorney Baldwin had knowledge or participated in. See affidavit of Mitch Westerman previously filed. I haven't seen that. Has anybody seen that? I need to go and find that. Oh, it's sealed. No, it's not. No. He said it wasn't sealed. That one wasn't sealed. I'm going to have to go and find that. Thank you, Mandy, for the 35 South African rand. If Rosie filed a civil claim, wouldn't that be a private attorney, not as a public defender? Yeah, presumably, yeah. But so it would be on his own dime. He'd be doing it, well, be doing it for free, I would assume. Anybody know where the reward is in the Delphi case? No. I don't. That's okay, little bear paws. Can rewind. Do a little rewind. Yeah, the judge has a major I am the queen ego. Yeah. Guideline 1.1 of the Indiana Public Defenders Council's performance guidelines for criminal defense representation states the paramount obligation of criminal defense counsel is to provide zealous and quality representation to their clients at all stages of the criminal process. Nobody can say they haven't done that. Surely nobody can say that they haven't done that. If nothing else, that memorandum has provided a huge amount of reasonable doubt. If nothing else, you can call it crazy, you can call it insane, you can call it lies, but at the same time, you've got to admit this is reasonable doubt. It's a good defense. It's a good defense. Similar obligations are recognized by the American Bar Association, the National Legal Aid and Defender Association, I think we're nearly at the end now, National Advisory Commission on Criminal Justice Standards, and Goals and Rule 1.1 of the Indiana something. Okay, everything cited by Judge Gull as concerning was either not attributable to Attorney Rosie or excellent and ethical lawyering in the best interests of the client, defense, mental and physical well-being. Yeah, all the issues that Judge Gull had were with Baldwin, not Rosie. And you can certainly say what they have done is in their client's best interest. Absolutely. Throughout the pendency of this proceeding, the defense has exposed untruths by law enforcement. They've held their feet to the fire, and they really have, right? You only need to go and listen to what Patrick Westphal said about being hauled back in for a 4.5-hour interview in August of this year, including a polygraph and DNA, which should have been done right there in February 2017. If they didn't think they'd done anything wrong, they wouldn't have done that. They would not have done that. They wouldn't have gone back and done that to Patrick Westphal if they thought that they were in the right. Mo, thank you for the $4.99. Keep it up. Thank you. Wow. Exposed untruths by law enforcement, withholding of exculpatory evidence by the prosecution, and discovery violations about which Judge Gull showed no concern and did nothing. The court has routinely expressed umbrage at defence counsel's representations through investigations and filings, while silently abiding the prosecution's discovery delays and false statements by them or their agents. Wow. On October 19th, Judge Gull coerced an oral request to withdraw from Attorney Rosie and did not comply with Rule 3.8H, Indiana Rules of Trial Procedure, and further coerced an oral request from Attorney Baldwin to withdraw as co-counsel. Judge Gull has exhibited a lack of concern about and taken no action to protect the physical and mental health of the accused. That's absolutely 100% true. That is what I've been saying since April. That's exactly. Fire the judge, Rosie for president. Yeah. That is exactly what I've been saying since April. You cannot try a dead man. It doesn't matter whether you think he's guilty or innocent. At the moment, he is innocent. At the moment, he is innocent. Right? In the eyes of the law, right? In the eyes of the law, he is innocent until proven guilty in a court of law. And they cannot put him there in a prison, a maximum security facility, supposedly for his own protection. And now we know that these Ordinance guards have been on the case, and they admit it, tasing him and God knows what. We know just how bad it's been. And the judge has done nothing about it. The judge has refused to allow him to be put in a place where he should be at this stage, i.e. a county jail. You can't try a dead man. And if he's not capable of, competency, if his mental health is so bad, then he can't be tried. And we've got take out all the Ordinance stuff from the memorandum, take it all out, strip it all out, and just look at the lies that law enforcement have told, or the ways that they've not focused on avenues that could well have proved more fruitful, and the potential for them to have framed Richard Allen. Take out all the Ordinance stuff and just look at that. And then tell me that there's no exculpatory evidence in this case. Throughout these proceedings, Judge Gull has exhibited a bias and prejudice against the accused and his attorneys in favour of the prosecution. Counsel for the defence are appointed pauper counsel, and upon appointment, judicial control and oversight of the appointed counsel is inappropriate. The court cannot and should not dictate the process of representation or improvidently curtail representation of counsel. It has done so without notice to the defendant, or I think this is the last page coming up. Oh no, one more after this. Or his counsel, affording them an opportunity to be heard. It was also done so of its own accord without any precipitating motion or request. No due process has been afforded. No due process. Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to disqualify him or herself when a judge's impartiality might reasonably be questioned. Such is the case in this cause of action for the reasons described below. Rules 1.2 of the Indiana Code of Judicial Conduct states a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Totally. As previously stated, Judge Gull strong-armed attorney Rosie and Baldwin with a prepared statement that she intended to read into the record had either attorney resisted or her efforts to remove them from the defence. Within minutes, Judge Gull took the bench, started the record, and informed those present of the viewing public that there existed an unexpected turn of events, with the defence team withdrawing from the case. Judge Gull further stated that these circumstances were clearly outside of our control. Well, they weren't. They were totally within her control. She lied. That was a lie. It wasn't an unexpected turn of events. The only unexpected thing, perhaps, for her was that she expected them to go into the courtroom so that she could read this into the record, you know, for the cameras that she especially allowed in. So she was pissed off. It was unexpected for her that they did that. But did they have any choice? No. And it was entirely within her control. That was a lie. The only clarity offered up by these statements is that they were entirely inconsistent with her actions in chambers just minutes earlier that forced the attorneys to consider withdrawal in this matter. These words run afoul of Rule 2.1 as they demonstrate the tribunal's lack of integrity and impartiality towards the public and usurp defendant Allen's right to competent legal representation. There's got to be an infringement. That Sixth Amendment, anybody? There's got to be. Rule 2.2 of the Indiana Code of Judicial Conduct requires a judge shall. Okay, we're nearly done. Shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Comment 1 to the rule states, to ensure impartiality and fairness to all parties, a judge must be objective and open-minded. So, the pertinent part states, a judge having knowledge that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer, in all respects shall inform the appropriate authority. It does not indicate that any such opinion of the court allows removal of appointed counsel without due process and against the wishes of the accused. Thank you. You can't just run willy-nilly with no due process. You can't. Thank you. Who was that? Dulcie. Member for 19 months. I always cover these things with passion. I think that should say passion. It gets me mad. Right, like Rosie, I'm Italian, so I move my arms about all the time and I get mad. Judge Gull has violated rules 1.2, 2.2, 2.3, 2.6, 2.8, and 2.11 of the Idaho Code of Judicial Conduct. How do they get a new judge? Well, she could recuse herself. She could agree to step down. If she doesn't, then they go to the chief judge of Idaho, I think. Not Idaho, sorry, Indiana. There's a chief judge. So they have to go there. They have to go over her head. Been watching me for years. 2 years. Don't comment much. No, I hardly ever comment on videos. This is already the second judge. Yeah, the first judge, Judge Diener from Carroll County, recused himself. He took himself out of the situation. He didn't want it. He didn't want the job. So that's how Judge Gull, who is in Allen County, got appointed. So if she refuses, which I think she will, I think she'll just say, "Are you having a laugh?" No. Then they have to go to the chief judge, whoever that is. I don't know who that is. But they basically have to go over her head and make the case. I think that's how it works. Now, there's one more document here. Okay. So this is a motion for continuance. So this is the other document. Now, this is only a short one. Oh. Why is it done that? Okay. Okay, I think, yeah, we're back now. I don't know why it did that. Okay, so this is a short one. So, okay. So, Counsel Bradley Rosie and respectfully request that this court continue for October 31st, 2023, hearing set in this case. In support of said motion, Defendant Allen states the following. So this is, what's this? Update available. Do I want to, no, I don't want to restart my computer. Go away. Why do they always do that when you're in the middle of something? Give you a message to say, do you want to restart your computer? No. Okay, so this is to continue with the hearing on the 31st, which was to go ahead anyway. That was a scheduled hearing, October 31st. On the 19th, Judge Gull said she would use that date to talk about Richard Allen's new attorneys. But what this is stating is that Brad Rosie wants that hearing to go ahead as a scheduled hearing, not one where new attorneys are appointed. So he's just assuming that it's going to continue. So counsel for Defendant Allen is unable to locate any specific order wherein the court scheduled the initial October 31st hearing date, nor is there any order which articulates exactly what matters were to be addressed and how much time was to be set aside to address said matters. However, counsel does acknowledge that there have been discussions between the court and lawyers regarding the October 31st hearing and the possibility of the court conducting a hearing on the pending suppression motion filed by Defendant Allen. On September 18th, Defendant Allen filed his motion for Frank's hearing. The court has yet to issue a ruling on said motion. So that's the release of the 136-page memorandum. That was the request for the Frank's hearing. So the judge has not even commented on that yet. On October 2nd, Defendant Allen filed a suppression motion for the Frank's hearing. The court has yet to issue a ruling. On October 3rd, Defendant Allen filed an additional Frank's notice. The court has yet to issue a ruling. So they've asked 3 times now for an answer on the Frank's hearing. And there you go. No, we can't have a Frank's hearing. No, I'm just going to fire you instead. I'm going to make up a reason and fire you instead. On or about October 14th, this court ordered Defendant Allen's defence team to cease all work on Defendant Allen's behalf and therein prohibited counsel from engaging in preparation for October 31st. On October 19th, the court engaged in actions which resulted in the court ordering the oral withdrawal of Attorney Baldwin and Attorney Rosie remains the only active attorney of record in this cause. Well, does he though? Because she fired him. So he's assuming he is. He's assuming he is. He's just continuing as if he is. On or about October 25th, so that's yesterday, Attorney Rosie filed a motion to disqualify. Attorney Rosie believes that a full and final deposition on the motion to disqualify should take precedence over the issuance of any rulings on the Franks motions, the disposition of the pending suppression matters, and any other matters of substance. So what he wants is for the October 31st hearing to be all about Judge Gull, to be all about, are you gonna step down or not? So he's forcing her hand here. Further, defendant Allen believes that any suppression hearing in this cause will require more than 1 day of the court's time and will require the appearance of witness, which most certainly cannot be secured between now and 31st of October. These reasons, defendant Allen requests that the hearing on October 31st be continued to a date and time following a full and final deposition of the motion to disqualify. Okay. Ball's in her court. Rosie is quite clever. He's very clever. Very clever. Very clever. Yeah. So whichever way the cookie crumbles, I mean, anything's possible now in this case. I'm not going to try and predict what Judge Gull does, but if I had to guess, if you forced my feet to the fire and I had to guess, I would guess that she'd just look at him and say, are you kidding me? What are you doing here, Brad? I've got 2 new lawyers. And she wheels 2 new lawyers in. Can you imagine? She makes him leave. She gets security. She gets the security to come and hoist Brad out of the court. And then as these 2 new lawyers. I mean, anything's possible now. It's possible, anything. Francis Seagull. I'm going to call her Seagull from now on. But who knows? Who knows? Anything could happen. But I don't think cameras are going to be at this hearing. Surprise, surprise. I don't think she wants cameras at this hearing. I think that was a one-time only because she knew she was going to name and shame the defense for doing what any defense should be doing, defending their client. So there you go. I don't think it's going to be, Jean. I don't think so. I might be wrong. She might change her mind. If she thinks she's going to perform some stunt, to embarrass Brad Rosie, she might allow cameras in. But she's damn shady. There's something very not right about that woman. All right, what's gone down in Idaho? Let's have a look. Just very quickly before I sign off, let's have a look what's happening in Idaho. Oh, Brian Koberger's trending. He always trends. Hold on a minute. Okay. Gonna have to... Oh, 6 grand jurors were relatively unimpressed with the state's case against Brian Koberger. Ultimately, there were enough votes for an indictment, but that was 5 months after what? Let's listen to Brian Entin. Let's see what Brian has to say. So this hearing's presumably still going ahead, like still ongoing. Okay. Brian Kohlberger just walked in. Hearing should be starting soon. Kohlberger judge says morning hearing was sealed because they were dealing with the procedures of the grand jury. And there was a lot of details. Grand jury proceedings are secret, so it has to be sealed, he says. Kohlberger judge reminds people that they are not allowed to record anything in the courtroom. Rules have been violated in the past. Oh, really? Police have surrounded a house in Bowden, Maine. Subject believed to be inside. If Brian didn't do it, who did it? Brian did it. Nah, I'll die on that hill. Kohlberger judge says he will not buy it. I can't even speak. Kohlberger judge says he will not ban cameras in courtrooms. Says instead he will take more control of the cameras. So, right, the judge is going to operate the camera from now on. Judge is going to sit at the back of the room and he's going to pan the camera wherever he wants to. Right, so he's going to be the cameraman from now on. Defense is arguing grand jury was given the wrong instructions, but judge says it's the same instructions given to grand juries for 100 years. So this was relating to, I did this massive video on it earlier this year. Well, I don't know, it was massive. I don't think it was really long, but yeah, I remember talking about grand juries and trying to condense all this massive stuff that the defense had put out, which was absolute nonsense, complete nonsense, going back to like the 1800s about the definition of probable cause versus beyond a reasonable doubt, and saying that a grand jury in Idaho, because at one time in like 1860 something, a grand jury presided beyond a reasonable doubt rather than probable cause. And it's like, no, if you change it now, every single proceeding since that time has to be redone. You can't change it. And there's no way that until a trial jury sits, until a jury of the defendant's peers sits down and publicly all of the evidence is put forward and then cross-examined, can you say that that defendant has to be proved guilty beyond a reasonable doubt? Up until that point, it's probable cause, the probable likelihood, the perhaps maybe the 51% that that person committed that crime. So, yeah, arguing that the jury were given the wrong instructions is insane. Ann Taylor, it's insane. Kohlberger defense making an argument now to throw out grand jury indictment. Prosecution is now arguing why Kohlberger grand jury indictment should not be thrown out. There is nothing to see here. The Idaho Supreme Court has ruled on this issue. Okay, let's refresh. So what was this nonsense that other person was saying? Okay, let's see what the replies are. Killers always have a scary look. Okay. All right. That's the way to judge a killer, is it? All right. Fair enough. Okay. Let's see what else it is. So what's this person? Where's this person got this information from? The fact that there were 6 jurors that were unimpressed with the state's case says a lot. A lot. No, it doesn't. It says nothing. Because how do we know that? Where have you got that from? Yikes! 6 grand jurors relatively unimpressed. Where have they got that from? Kohlberger really thinks he's the smartest guy in the room. Yeah, all right. What a Court TV saying? I think I probably should just wait to see what comes out rather than following these threads. All right, Chanley. Got her out in court on here. Okay, so what's happening with this shooter then? Who's trending? Why is it not trending anymore? Oh, Robert Card. There he is. Oh, police and FBI are surrounding a house on the 900 block of Meadow Road in Bowden, Maine. It appears they believe Robert Card is in the home. Okay, where's that at? Hold on. $900 Meadow. 900 Meadow Road. Bowden, Maine. Okay, that's where it's giving me. 900 Meadow Lane. It's in the middle of nowhere. So where was he at? Where was he at? Lewiston. $16 miles away. So I wonder who owns that place. Multiple FBI agencies are currently at a residence. Do you know what I think he wants? I think he wants suicide by cop. I think he wants to draw them into a gun battle. NBC News reports that a note was found in Robert Card's home as investigators executed a search warrant. Firearms instruction, blah, blah, blah. Began to hear voices that were saying horrible things about him. He was also sent for treatment by military commanders. So, schizophrenia. Or MK Ultra. Could be that. Well, I don't think they need the Coast Guard. If he's in the house in the middle of the woods. So 914 Meadow Road, Borden, Maine. So we've got a more specific address now. 914. Take me right there. 914 Meadow Road. Okay. Oh, it looks nice here. Well, that's 908. All right. Maybe I've got to move on. Maybe that's it. 926. Where's 914 then? 911. Where's 914? Anyway, it looks a very nice leafy area. That's like a farm. Yeah, there's a farm there. Interesting. I wonder who lives here. That's 908, so I don't know where 914 is, but anyway. He abandoned his car by a boat dock. That's why they called the Coast Guard. Yeah, I know. They thought he was going to try and swim for it. Because he had a boat, didn't he, or something? It is lovely countryside. It honestly looks like a lot like where I live, to be honest. Maybe a bit flatter than where I live. But then again, if you go like a few miles to the west of where I live towards the coast, it's very flat. Very, very flat. I live on the edge of the hills, but it very soon becomes very, very flat. So this looks like West Lancashire. Looks very much like West Lancashire. Man, it's not flat at all. It looks flat. Look, just by this road here, it looks flat. It looks like West Lancashire. It looks like you could walk out and walk on a flat surface for a while at least. Let's have a look. See, that's pretty flat, that. Oh, there's a hill there. Oh, there's quite a big hill there. But that little area was flat. It must have been in a valley. Well, there's quite a few miles of flat. Look, it's all flat. It looks a lot like where I live. Like if you look where I live, like from the air, that could be Lancashire. It could easily be Lancashire, like the rural area of Lancashire. That could be. But I digress. I want to just see if they catch him. Just storm in there. Just blow the place up. I know they can't do that. Don't start flaming me. I know they can't do that because they don't know who's inside. Coburger grand jury indictment stands. Court adjourned. Yay! There we go. So what I can't understand is where this person on Twitter got this that 6 grand jurors were upset. Where have they got that from? Yay. Judge said we'll also enter a written decision, but can't guarantee it will be 32 pages like the defence's motion. Yeah, that's what I was saying. It was massive. All going back to like 1860 something. It was painstaking to read through. Wow. Let's retweet that. Legal arguments and history were fun. Go on, I learn some more, he said. I like him, Judge. I don't think I like him as much as Judge Newman, but then again, I don't know him as well as Judge Newman. Not yet, anyway. Anyway, guys, I'm going to go. We got waylaid a little bit. But hopefully, today's the day to catch that nutcase in Maine. And there's another shooter in New Jersey, somebody said earlier on. From their dull imagination. Well, to be honest, look, there's not very much for the defence to argue in Coburger's case because he's clearly guilty. Look, if they seriously had exculpatory evidence and evidence of law enforcement lying, like there is in Indiana, Ann Taylor would have a point. Ann Taylor would be able to file some beautiful motions and she wouldn't have to go back to 1860 something to get a point across. In which case, she would have perfect right to exercise as many nitpicking points as she wanted. It's like night and day in the cases. It's his brother's house, is it? Well, his brother lives in a nice area. Are they just assuming that he's there because that's his brother's house, or do they have like sight of him, or are they just swarming the place because he's not at his house, he's not gone to his boat, therefore let's check his brother's house. In Indiana, you have an attorney general. They have good intel. Okay. So there'll be snipers in all the trees and everything. It'll be like Shooter. Has anybody seen Shooter on Netflix? It'll be like that. Oh, I wouldn't like to be living on that street, because I'd be like the person who'd go out and have a look what was going on. I'd be there walking along, pretending to be like, oh, the dogs just need a walk. The FBI come along, like, what are you doing? Why are you here? Go inside. There's a shooter in that house. Yeah, what? What? Oh, sorry, I didn't know. And then I'd go in pretending I was going home, and then I'd just go around the back and have a look there because I'm nosy. What's this? They call loud bangs were heard. Oh no. What? Oh no. Was looking for his ex when he shot 18. Not found in home. Oh, is he like Royal Malt? That kind of nutcase. Explosions are coming from inside the home. Wow. Well, suicide by cop. Or maybe suicide at his own gun when he knows he's surrounded. Oh, why are they making it political? There's a time for that. I get it. But there's a time for it. But it's not when the FBI have got this guy cornered. Ask the questions after. Oh, a huge standoff at the residence. Heavy military and police proximity. Gearing up for a shootout. Negotiations with this. He's not going to surrender. He's going to either shoot himself or come out shooting. What's she doing? That would be me. What's she doing? Right, they're all there with the Kevlar on, and she's just stood there with her hands in her pockets. It's like, oh, I like bullets can't harm me. I'm bulletproof. I'm bulletproof. I am. Me, yeah. That Like just pretending to be a tree or something. Like pretending just to be. I'm not. Don't. You didn't see me. You didn't see me. I'm just standing here, minding my own business. Looking into possibility that Robert Card was targeting a current or former girlfriend when he went to the bowling alley and the bar. Not confirmed as if she was in either location. Oh dear. So 18 people had to lose their life and 13 other people had to be injured who possibly potentially die in the near future just because he was pissed off with his ex. All right then. I do wish I could teleport. Nearly every day I wish I could teleport. She's on a property, looks like she's filming them with her camera. Yeah. She's fearless. I'd have tried to get a bit closer to hear what they were saying I'd be hiding behind that tree there. I'd sneak there to see if I could hear what they were saying. Being camo should. Well, I'm going to go. Hopefully they catch him or he takes himself out. You know, I like it when the rubbish takes itself out. Do like that. And no one else is injured. Especially that woman in blue there who's just minding her own business. All right, guys, I'm going to go. I want to see what's going on YouTube. I've not been on it for a bit. Well, I know I'm on it now, but I want to see what other people are saying about this astonishing events in Idaho and the entirely expected events in Idaho. No, did I say that wrong? In Indiana. Indiana and Idaho. It's like the similar names. So the entirely unexpected, shocking events in Indiana, and then the entirely expected events in Idaho. I said it right that time. Okay. All right, guys. Thank you for joining me. Hope you enjoy the rest of your day, your evening, your afternoon, wherever you are in the world. Thank you, as always, for the donations. As always, thank you to the mods, and I'll see you in the next video. Bye, guys.